Kathy represents national and regional securities brokerage firms, clearing firms, and officers, employees, and independent contractors in customer disputes, regulatory inquiries and investigations, internal investigations, employment disputes, and rating and recruiting litigation and other disputes between industry members. Kathy has served on the faculty for training programs for FINRA and the American Arbitration Association, and she conducts compliance and legal presentations for broker-dealers and other financial services firms. Please welcome Kathy Klock.
Thank you and good morning. Alternative investments, which include, among others, non-traded REITs, business development companies or BDCs, funds of hedge funds, and other alternative products, have a unique ability to strike terror in the hearts of compliance professionals. They also present unique challenges to financial services firms because alternative products typically offer substantially higher returns and yields to investors. However, the characteristics and risks of these products differ substantially from traditional stocks, bonds, and mutual funds. They carry higher yields because they carry significantly higher risks. They are often illiquid with little or no market, and they are complex, and they may be difficult for the broker who's recommending them to understand. They may be difficult for the supervisor of the broker to understand, and they are definitely difficult for your average investor to understand. In low interest rate environments like we are in right now, there is a flight to yield, both by institutional investors and retail investors. And these retail investors may include retirees who are looking for higher yields on their money, but who cannot afford the risk of a loss of principal. The August 2013 Investment News reported that sales of non-traded REITs and business development companies are soaring. Capital flows into illiquid investments. Securities hit record levels in the first half of 2013, totaling more than $10.7 billion, the highest half-year total for the industry, and an increase of 65% over last year. An alternative investment is not suitable for an investor regardless of the yield if the amount of the investment is not appropriate in light of that individual's net worth, liquid net worth, if the investor does not understand the product, or if the investor cannot afford a risk of the loss of principal. Each of the cycles of the firm's responsibility for alternative investments is important to protect the customer, to protect the firm, and to protect the individual rep who is selling the product. This includes the first step is due diligence, the compliance policies and procedures for alternative investments, the education and training of your investment professionals, the customer suitability at the point of sale, the disclosures made to the customer prior to and at the point of sale, the supervisory controls the firm has put in place for these products, which have to be unique for alternative investments, and as we'll go through today, there is a heightened supervisory responsibility for alternative investments. FINRA notice to members 371 mandates that member firms conduct adequate due diligence to understand the features of the product, perform a reasonable basis suitability analysis, perform customer-specific suitability analysis, provide a balanced disclosure of the risks and rewards, and implement appropriate internal controls and train the registered representatives on the products. Notice to members 559 has similar guidance with respect to the sale of structured products, and that is a requirement that the firm provide balanced disclosures in the promotional materials, ascertain the accounts that are eligible to purchase structured products, which is one of the foremost responsibilities in the due diligence process, deal fairly with customers with regard to derivatives, perform a reasonable basis suitability determination, a customer-specific suitability determination, and supervise and train the investment professionals. The due diligence is the first line of defense for the firm. It's a process that, that financial services firms probably have the most control over. And FINRA requires that in the due diligence process, that at a minimum, the procedures have to include clear, specific, and practical guidelines for vetting the products, ensure that the right questions are asked and answered before a new product is offered for sale to your customers, and when appropriate, provide for post-approval follow-up and review, particularly for complex products or products that are approved only for limited distribution. Notice to members 526 encourages members to engage in the following processes in the vetting process: to evaluate the complexity of the product, to determine whether the product would impair investor knowledge, the complexity of the product will impair investor knowledge, how the complexity will affect the marketing of the product, and whether less complex products would achieve the same objective for the customer. Regulatory notice 1022 provides that when you recommend a product to the customer, you have made an evaluation that this product is suitable, that you have conducted due diligence, and that determination is part of the process. In the context of alternative investments, the due diligence process needs to include evaluation of whether this product, the individual product, is appropriate to recommend to any retail customers, and if it is, the profile of the customers that the product may be suitable for. The reasonable basis suitability analysis. Complex products, again, offer the opportunity for greater yields, but they expose clients to the underlying market risk, the sector risk, credit risk, and liquidity risk, which is typical in these types of products. Supervisory procedures must include guidelines that are specific enough to identify the customers for whom the product should be offered and those to whom it should not be offered, the suitability criteria specific to that product, and approval procedures and surveillance tools to ensure that the firm's supervisory procedures, the suitability guidelines, have been followed. And again, as I indicated earlier, these are heightened supervisory requirements when they come to alternative investments. Firms are also required to provide a balanced disclosure of the risks and rewards of the product. This is typically found in a prospectus. You may also want to have these types of disclosures in the application. And also, an issue I'll discuss a little more later, the disclosure documents signed by the customer. These documents should provide very effective evidence that the risk disclosures have been made, that the customer understands the risk of the investment, and evidence that the customer has reviewed and received and reviewed the prospectus. The sales materials also have to have a balanced disclosure of the risks as well as the rewards. The next item in the cycle is internal controls. This is another area where the firm has a significant amount of control, and that is with the product education and the knowledge that brokers are required to have before they're permitted to offer these products to the public. In addition to the reps who are offering these products, if their supervisors are not knowledgeable enough about the product to ask the right questions and to make an independent determination as to whether or not the specific product is suitable for a client, then the supervisory process will not be effective. Again, the suitability criteria should be established for each product, and you should have documentation of the suitability, the disclosure of risks. One of the areas that are particularly important for these types of products is the firms need to evaluate what percentage of a client's liquid net worth are suitable for an alternative investment. Not only for the initial purchase, but if the client made a decision to purchase more, what percentage of their net worth a broker may be permitted to make that recommendation for. You should have strong policies and procedures regarding the disclosure documents that are provided to the customer to ensure that the proper disclosures have been made with respect to risks. The training of registered reps, as I've indicated, are probably one of the most important areas that you will engage in to protect the firm, to protect the broker, and to protect the customer. If the broker does not understand the product, he cannot explain it to the customer, and he cannot explain the risks. And these products typically involve complex risks. You really have to understand the product, and you really have to understand the risks in order to communicate that information to the customer. And then have compliance policies and procedures that relate to this process. All of the steps in the process are important, but the steps that the broker-dealer has the least ability to control is the point of sale disclosures and representations made by a broker, and that is why it is so important to have strong documentation. When a customer makes a complaint either in a FINRA forum, in a court, or to a regulator, the arbitrator or the regulator will not have the benefit of sitting at the kitchen table with the customer and the broker, or be on the phone when this product has been thoroughly vetted with the customer. They're going to be sitting in a hearing room with a customer who is going to be explaining while they're weeping and having their tissues out how they explained to the broker that these were irreplaceable funds, that they worked their entire life to save this money. And they told the broker that their paramount concern was that they didn't lose any of their principal. They thought they were investing in a CD. Anybody in this room who has litigated these claims can tell you, however ridiculous this may sound, this is what happens in an arbitration, and they're coached to say these things. And so if you have documentation where the customer has actually disclosed what they've been told and what they understand, it's very difficult for the customer to be able to make these types of claims. For example, some firms now have 4-page disclosure documents for alternative investments. The customer has to write in their own hand sometimes, their own handwriting. They'll give them a block that says why they're purchasing this. They have to either initial or sign specific disclosures. They receive the prospectus. They had a conversation about the risk. They understand the risk. And they'll say, I understand that this is illiquid. I understand that there may be no market for this. I understand that the income that is projected to be generated from this investment may not be realized, and there may be no income, and in the event there isn't, I may not be able to sell it. In addition, I recommend strongly that any disclosure documents you have state the specific amount of a customer's liquid net worth. This is an area that customers typically do not like to disclose, but if they're in the position, if you're selling them a Reg D offering or something and they're signing an investor questionnaire, they're going to disclose specific information, and this is the same type of situation. Because if you have ranges of net worth, for example, a lot of brokerage firms you'll see, it's, I've got, my income is 100 to 200, my net worth is 500, my net worth 500 to $1 million, $1 million to $5 million. Well, if you're looking at a non-traded REIT investment of $400,000, there's a big difference between $1 million net worth and a $5 million net worth. So it's very important that the actual net worth, of the liquid net worth of the client is indicated on your disclosure documentations. Education is very, very important that you have specific product education. It's not enough to have a broker represent that he has read the prospectus or she has read the prospectus. Number one, that probably didn't happen anyway. But I think that before someone is permitted to recommend a particular type of a complex product, they should have to have some type of specific product training that the firm has approved. And there should be documentation of that training, because if they don't, again, if they don't understand the product, they can't make the client understand the product. And if the client doesn't understand the product, they're more likely to sue because at the time they purchased it, they didn't realize that these risks were associated with the investment. The other issue is that you are going to have wholesalers, product wholesalers in your branch offices, and they are going to be extolling all of the benefits of the investment, but they are typically not going to highlight the risks because they're there to sell. And your brokers are there to sell. And oftentimes these products will carry an attractive commission on them as well, and human nature is going to make them more prone to recommend these investments in situations where maybe they should not do that. But if you educate them not only on the product, but on the consequences of making a recommendation that's not suitable or failing to disclose the risks and the particular risks of a complex product in an alternative investment environment, that can be a very effective tool. One of the things that I have found most effective in the training of registered reps is in the session to have actual cross-examination, a mock cross-examination from an arbitration. For some reps who have never been in an arbitration environment, they're horrified, because they may tell you, well, this client wanted these REITs because he understands real estate, and he has a lot of real estate. And so he was more comfortable with this. Plus, he lost money in the 2008-2009 financial crisis, and he's shy. He doesn't want to go into the market. Well, number one, if he owns a lot of real estate and you're selling him a non-traded REIT, you're probably creating a concentration problem for this customer. And if the customer doesn't want to go into the traditional stock market because they lost money in the crash, well, they need to understand that there's a high risk of loss here. And so it's not enough to have these superficial considerations or reasons for your recommendation. And if you do these mock cross-examinations in an arbitration or a mock cross-examination by a regulator, you get through to them that they really and truly need to have a deep knowledge, and the customer really has to be knowledgeable about the product. As to the disclosure documents, I also recommend that if you have the customer sign them, that you follow the procedure that typically brokerage firms do when a new account document is signed. After the customer has signed it, you then send it to the customer either in an electronic form or a copy of it with a letter asking the client to advise if there's any information on this document that is incorrect. Because whenever you have a case where you have a very strong documentation that the broker has filled out in part and then given to the client to sign, the client almost universally will testify, I signed it in blank, and the broker said he would fill it out for me, and I never saw it again, and none of this is true. In order to protect yourself against that, you either have the client complete the document in their own hand, or even better, you send the document to the client, particularly where there is a significant investment in an alternative product, because that will give you great protection in the event the customer sues or in the event you become the subject of a regulatory investigation. The complex products which FINRA has communicated specific concerns about include business development companies, leverage loan products, commercial mortgage-backed securities, high-yield debt instruments, structured products, exchange-traded funds and notes, and non-traded REITs. Additional materials that I think you might find helpful in this area is FINRA Regulatory Notice 99, and these documents will be in the materials you received today, and that deals with unlisted REITs and DPPs FINRA Regulatory Notice 12-3, complex products and the heightened supervisory requirements attendant to those products. FINRA Regulatory Notice 13-18, communications with the public, and this is guidance on communications regarding unlisted real estate investment programs. And then the last slide I have for you today is FINRA Investor Alerts and Sweeps. In June of 2013, there was an article that came out on Reuters from FINRA, that FINRA to warn investors on alternative securities. There was a FINRA Investor Alert on leverage and inverse ETFs. And there was a FINRA Investor Alert on alternative funds. It says alternative funds are not your typical mutual funds, and they are not. And then FINRA 2013 Regulatory and Examination Priorities Letter. This was a FINRA sweep that's focusing on alternative investments. So this is an issue that is very real and very timely, but one that with proper compliance policies and procedures, with education, and with documentation that all of these processes have been complied with and the customer has received adequate disclosures, I think that you'll be in a very good position to defend any potential claims, to defend a regulatory investigation, and most importantly, to have a successful business relationship with your clients. Thank you.